All right, the court will call next CW, the mother of NR, LW, and ZW versus Department of Children and Families.
May it please the court. I'm Heather Moorcroft for CW, the mother. This case was initially a dependency case, became a TPR case. In the dependency case, the fathers were not served. In the TPR case, all of the fathers were served. Everybody was before the court. So I want to start out by saying that the court had jurisdiction of all the parents in this case. My argument is that the appropriate statute for the court to be using was 39811. There was no dismissal of the TPR. There was no abatement of the TPR, no order abating the TPR. The father was properly before the court when all of these decisions were made. The court could not have abated or dismissed the TPR because the
court did do that, didn't it?
No, there was a mediation where the parties sort of agreed to abate, but not the mother. The mother consistently did not agree to that. There was no mediation agreement ever admitted. There was no actual order ever abating. There was no order dismissing. And the petition itself was never amended. This was initially a two-parent TPR on grounds of abandonment as to the father and failure to finish the case plan and abandonment as to the mother. In order to only have a one-parent TPR, the guardian ad litem, who was the one who brought the petition, it was not the state, would have had to amend the TPR petition and allege grounds for a one-parent TPR, which was never done. So to say that they had abated and the father had sort of gone away is not what actually happened in this case. You can't have a one-parent TPR without grounds, and that's under 39811. And
was there ever a TPR as to the mom? There wasn't, was it?
There was a TPR petition filed.
But I mean, there's never been an adjudicatory hearing?
No. Well, there was a trial.
It's just a dependency case as to her, correct?
Well, no, there was a trial, a TPR trial, and the court found that there was no TPR. And under 39811, what happens when you find that there is no TPR is that the court then either dismisses the whole case or determines that there is instead a dependency. And then they have to dispose of that case under 39811. So at that point, what should have happened is there should have been, if they wanted to place the child with the father, there should have been an ICPC, because the court can only forego the ICPC when the court has terminated jurisdiction, which they can't do under 3911 until 6 months have passed. So the ICPC should have been completed.
What is an ICPC?
An ICPC is an interstate compact for the placement of children. And under the HP case, a child can be placed with a parent without an ICPC or with just, a sort of informal home study if the court has terminated jurisdiction. But where the court has not terminated jurisdiction, then the ICPC, which is a more formal process where the Children and Family Services in the other state has to send someone out and do a formal home study and look at the home, has to take place. Then where the court still has jurisdiction, the court doesn't have the authority to waive that ICPC. And if 39811 applies, then the court has to retain jurisdiction for 6 months after they make that decision that, no, we don't think there's clear and convincing evidence of a TPR. We're going to go ahead and continue this as a dependency. Then they have to go ahead and keep that supervision open for 6 months, and they would have to do the ICPC. And at that point, it doesn't matter whether they have found dependency based only as to the mother or as to the father, because this court found, and I cite the case in my brief, that the dependency is as to the child. So if there is dependency, then there is dependency. And even though in the initial dependency case they had not properly served the fathers, if this had all been under the initial dependency case, then the respondent's argument would be correct, and 521 would be an appropriate method to dispose of the case. But because this was a TPR action involving all of the parents who had been properly served and were properly before the court, the appropriate statute to apply is 39-811, not 521, and it changes the entire analysis.
Let me ask, what is the effect of the court's order, the 19th of August order, where they placed the child, but the court said the court hereby dismisses the TPR petition in regards to the mother and father, and the court dismisses the TPR petition. What does that mean? Well, under
39-811...
Just tell me what you think that means. In that dismissal of the case? By the judge? Signed by the judge?
No, because under 39-811...
So the judge couldn't do that? Is that what you're saying?
The judge can dismiss, but the judge...
In other words, that's what the judge...
If the judge simply dismisses the petition,
yeah,
then all the children would go home. This case is still going on.
Well, it would seem like there's still a dependency case as to your client, correct?
And then that means, if you look at 39-811...
There was no dependency case as to the dad, correct?
Pardon me?
There was no dependency case as to the dad. He was a party to the TPR, correct?
Right, but if under 39-811 there are specific things that the court can do, and the dependency case is not as to the parents. You don't have a dependency as to mom or as to dad. The dependency is as to the child. So if the court finds dependency...
Well, who are the parties? Are the parents a party to that?
Yes, and the child is a
named
party.
Up there at the top? Yeah.
Yes, but the dependency...
But the dad wasn't named in the dependency petition, correct?
But it doesn't revert back to the initial petition.
Really?
If there is a TPR petition, what happens is under 39-11, if the court finds that there is not clear and convincing evidence as to a termination, they then adjudicate. If it was an expedited TPR, they would adjudicate the child dependent. If there has already been an adjudication of dependency, the statute specifically says that they re-adjudicate the child dependent. So there's then a re-adjudication of dependency. That would mean that as all the parents had been served, that re-adjudication would properly apply and would include all of the parents because they were properly served for the TPR. So it doesn't just revert to the original dependency, and that would make sense because in the original dependency, the case plan had expired. You now have a re-adjudication, so you would then be required to give all of the parents a new case plan, because case plans only last for 9 to 12 months.
Well,
and
a non-offending parent doesn't have a case plan, do they?
But there were actually, yes, sometimes there are case plan tasks for a non-offending parent, but the TPR petition specifically alleged abandonment as to this father. So he is no longer a non-offending parent.
That got dismissed.
No, the TPR got dismissed. So she's now got to re-adjudicate, the court now has to re-adjudicate dependency. There was never an evidentiary hearing as to the facts regarding this father, not even under the 521, which there should have been. Because under 39-521, you're required to have an evidentiary hearing. And one of the, that's also a 5th DCA case cited in my briefs. There was scheduled an evidentiary hearing for August 18th for this 39-521 hearing, but it never took place. So there was never, pardon?
What relief are you seeking in this appeal?
What relief am I seeking? I'm seeking an evidentiary hearing to determine whether or not the father is an appropriate placement for this child. Because there never was an evidentiary hearing, there never was an ICPC, this child was just sent up there. So to determine...
The dad did his own home study, evidently, is that right?
He did...
He did a criminal, there was a criminal background.
There were some pictures, but
Yes.
there's been no follow-up, there's been nobody checking, there's been no supervision. So what we're seeking is a determination as to whether or not this actually is an appropriate placement, whether or not the child is doing well there, the things that should have happened to assure that this placement was okay. Because it is true that if this placement is appropriate, a parent would be a preferred placement over a grandparent. But because this was never done the way it should have been done, and because the allegations were all along that this parent had abandoned this child, and
Well, those are not sustained, right? Those allegations
there was
were not-
never an evidentiary hearing, either under the TPR, because the father didn't actually
Didn't the child go up there and
attend.
visit his dad? Wasn't there a visitation with his dad?
The visits had primarily taken place in Florida. I think
He
there
had
may have been one
So he
visit.
visited with his dad. Did he visit in Ohio also at some point?
I think there may have been one visit in
There was
Ohio.
supervision over, someone checked on that, correct? That was kind of when the case was ongoing.
Nobody from here went
The
up
argument was,
there.
well, he's never seen his dad, he's been with his grandmother.
Nobody went up there and nobody from here went up there and visited him.
They have anybody from up there who go visit?
Not that I'm aware of, no. It was all things that he provided. I was not the trial counsel. It was all things that he provided to the trial court himself, I believe. So, and there was significant testimony that when he visited here, all of the contact and all of the initiation of the visits were from his grandmother. There was also a significant bond between NR and his brother that was severed by this change. And I don't know that there's been any ongoing
They
visitation.
have different dads, right?
Yes. So that's what we are seeking, is that we have that evidentiary hearing, because this court, not a different district court, has made prior pronouncements on these issues about the way these things are supposed to work.
The dad has to come in even though he hasn't been accused of anything, and he has to prove that he's a fit father?
Well, the law requires that before the placement occurs, that happens. And I would remind this court, since this has occurred, there has been no supervision. So for all we know, there could have been Department of Children and Families involvement in Ohio that we don't know about. We have no idea what has gone on in Ohio with this child since he's been placed, because the court terminated supervision and jurisdiction, so we don't know. Now, down here, the court has continued supervision of the other children, that the case has continued. But with this child, it's all been closed, so we don't know what has occurred. And I think that sets forth my
All right.
contentions pretty clearly, so I will retain the rest of my time
All
for
right,
rebuttal.
you certainly may.
May it please the court, my name is Thomas Young. I'm arguing today on behalf of the pro bono attorney who is the guardian ad litem in the trial court. The father's attorney, Ryan Truskowski, has ceded his time to me, and The Department of Children and Families is not participating in this appeal. The mother's argument rests on...
So you're pro bono too, here today?
I'm pro bono as well today, Your Honor, yes. The mother's argument rests on an unconstitutional application of Section 39-811. In a vacuum, that is the statute that would apply following a termination of parental rights proceeding. The problem in this particular case is that the Department of Children and Families denied the father due process by not providing him notice of the fact that his child was in state custody for more than 2 years. It is undisputed
That's originally, in other words, at the time of the dependency petition, he was never served or anything.
He was never served, never told that that his child was in state custody, at least by the state.
Okay.
Doesn't sound like he was doing much to stay in contact with a child if he didn't know those things on his own.
Well, Your Honor,
was he kind of concerned whether he was the dad or not? Wasn't that part of it?
that was a different father for
That
a
was
different
different than
child.
this one?
Correct. That's a
that was
different
another
father for a
dad.
different
Okay.
child. Your Honor, there's a lot of information that's not in the record, so while I understand your statement, that also doesn't take into effect sometimes family dynamics. What Your Honor must keep in mind is that this child was placed with a maternal grandmother that has contact with the father in Ohio, and sometimes family members keep things from each other, right? So this father is having, according to the record, telephone contact with his son. His son's living with his grandmother. His mother is a drug user. So to this young child, this may be normal. So he may not know, hey, Dad, I'm in state custody. So yes, to adults objectively looking at it, we can say this dad wasn't asking or whatnot, but the grandmother may have had a motivation not to tell him. The child may not have understood. So we don't know. The record doesn't show what this man knew or didn't know.
Is your position, you begin your discussion by saying that it's an unconstitutional application of the statute. Is it your position, lay aside the constitutionality of the statute for a minute, if we just read the statute, would we be compelled to go along with Ms. Moorcroft's position on this? If all we did was look at the statute in a vacuum without addressing its constitutionality?
And without looking at surrounding facts.
Right. I'm just saying, given the procedural history of the case, would we be compelled to adopt her position? And the reason that I ask is that, we obviously try to not answer constitutional questions if we can. So what I'm trying to understand is there a way to avoid addressing the constitutionality of the issue, or must we, if the statute actually says, in your mind, the same thing that Ms. Moorcroft thinks it says?
Your Honor, I don't think you have to reach the constitutional issue, but I think the reason you don't have to reach the constitutional issue is because you must consider the factual circumstances of this case when you're looking at whether to apply Section 39-811. I think you don't apply, in this particular case, Section 39-811 because the father had undisputed rights under Section 39.521 that the state denied to him by not providing him notice of the pending dependency proceedings for 2 years. He had an undisputed right under 39.521 3B1 to custody of his child. Briefly, that statute says if there's a parent with whom the child was not residing at the time of the dependency petition who desires to assume custody, so far, Mr. J.R. is fitting the statute. The statute then goes on to say the court shall, it's mandatory, shall place the child with that parent. upon completion of a home study, unless the court finds endangerment. So
The home study in this case, I was trying to find what it was, and the best I could tell that it was somehow referred to as an informal home-cooked. I mean, does the father just come in and say, well, I got a nice home and it's an adequate place? I mean, I didn't get the impression that any licensed agency or state agency gave it the seal of approval.
you're correct that this was a home-cooked home study, if you will. It certainly wasn't ideal. 521R sets forth what a home study should contain. That provision, however, does not apply to parents. If you look at the language of that provision, the word parent does not appear anywhere in it, whereas in the provision immediately preceding it, Q, they use the word parent. So by using the word parent in one place and not using it in another, the legislature evidences its intent, along with its express reference to relatives or other adults, that this is going to apply to non-parental placements. And so what we have is a little bit of a gap in the statute. The legislature doesn't say what the home study must be comprised of when a parent is involved under 521(3)(b). So I think it's discretionary with the court.
In dependency proceedings, I mean, I think we all agree that the interest of the child, the safety of the child, is a paramount interest. I guess one of the concerns that I have in a situation like this where nobody has laid eyes on the father's residence, I mean, we really don't have any way of knowing from the record, and I suspect you're in the same boat, whether dad lives in a nice house, a wonderful house, or it's a crack den. I mean, he apparently just said it's fine. And so how does the court carry out its responsibility to ensure that there's no endangerment if it relies on testimony that may or may not be reliable, but it certainly isn't from any objective party?
Your Honor, if I may, ever since the day of the apple in the garden, the world has not been a perfect place. And the Supreme Court says this about parental rights: the state may not intrude upon the parent's fundamental right to raise their children except in cases where the child is threatened with harm. It's the state's burden to prove unfitness, not this father's. The Department of Children and Families dropped the ball. So, do we have an ideal situation? Absolutely not. Should things have proceeded differently? Absolutely so. But was it this father's obligation to sit on his parental rights until the state decides at some point to do its job? No. He has the right to say, I am a presumptively fit father, and if you don't have the wherewithal to prove me unfit, give me my child. That's what he did, and that was his right. And if the court makes excuses for the Department of Children and Families, then the dependency practice at the trial court level never gets any better. And so at the end of the day, this case is about making it safer for kids by telling the Department of Children and Families, do your job. If you have concerns about a parent, prove your case. But if you don't carry your burden of proof, then that parent has a right to custody of his child. This child had a relationship with his father. He had ongoing communication by phone. He had been with his father when the father lived in Florida. He had visited the father in Ohio previously. He has half-siblings in Ohio. Much of what the mother's brief is arguing is fact-based, and the trial court heard all that and made the decision. Now, let me briefly transition over. Ms. Moorcroft is correct when she says there was never an evidentiary hearing in the trial court. Again, should there have been? In a perfect world, yes. But if you look at the record, this matter came for hearing off and on throughout the course of the termination proceedings. It was a multi-day hearing over several months. And so this issue was brought up over and over and over. Not one time in those transcripts do you see the mother's counsel demanding an evidentiary hearing. At the August 5th hearing, they did agree that there would be an evidentiary hearing on August 18th. For whatever reason, the record does not explain, does not say that evidentiary hearing did not occur, and the order at issue came down on the 19th. There was no motion for rehearing filed. So I think the mother has a severe preservation issue as well, because there was never a demand for an evidentiary hearing, and there was never a request to get the case back on track afterward. Again, the reason I'm asserting that the mother's argument rests on an unconstitutional application of 39-811 is because the mother is looking at that statute in a vacuum without considering the factual circumstances. The father had an absolute vested right under 39-521 that he never had an opportunity to exercise because the state did not serve him with process and appoint him an attorney. And so the trial court was entitled to go back and look at that father's and to give meaning to that father's vested right. And that's why it's appropriate to use 39-521 under the facts of this case.
You're representing the guardian ad litem.
That's correct.
And the ad litem's job is to advocate for the best interest of the child.
Correct.
You know, and I appreciate what you're saying about the father's rights here, but if you're advocating for the best interest of the child, how is that argument possible if we don't know anything about the living conditions that the court has sent this child to?
Your Honor,
I understand your argument. If you were making the argument for the father, I think it'd be a great argument. But I'm trying to understand from the child's perspective. I mean, I think if I were... Help me understand how your argument is not more appropriate for father's counsel than it is for the child's advocate.
well, I think they merge in this case, Your Honor, and I can tell you what I understand from reading the record. I was not the pro bono guardian ad litem in the trial court, but this case originated in 2006. So N.R., the child, was in limbo for more than 2 years. He was placed with his maternal grandmother, and based on the record, by the time of the TPR case, the grandmother had bounced that child in 5 different homes. So the child is not maintaining the kind of relationship with the father that the guardian ad litem in the trial court apparently felt the child was entitled to have, and the child was not getting stability with the maternal grandmother. The guardian ad litem apparently, again, based on the record, believed that the maternal grandmother was not an appropriate placement for any of the children, and was trying to seek some stability after the department had left this kid in limbo for more than 2 years.
I guess my question really comes down to, although the father certainly has the presumption that he's a fit parent unless the state can overcome that, I'm not sure that that's necessarily in the child's best interest. I mean, the child probably doesn't know whether the father's a fit parent or not, and so I'm wondering if the guardian ad litem doesn't have an obligation to try to determine, before advocating we'll send the child here, there, or anyplace else, determine the fitness of that placement.
Well, the record does not show, Your Honor, what the guardian ad litem may have done in terms of investigating this father outside the courtroom. What the record does show is that the father provided some information concerning his stability, his lack of a criminal background, and so forth. There was a mediation. I don't know what was said in that context, but the pro bono guardian ad litem in the trial court had some information, and for whatever reason made his subjective determination that this father was appropriate for NR and enabled NR, and keep in mind that a child has not only his best interest, but he has legal rights too, and he has a legal right to a stable home. And the guardian ad litem here was saying the state is not giving this child the stable home that is his right. And this father to the pro bono guardian ad litem seemed appropriate. And so it was a way to meld the father's interest with the child's interest and the child's right. Now, whether the court would have made that same judgment call, whether I would have made that same judgment call, we can't say because we weren't there, we didn't do it.
So I guess my point, though, is that there's nothing in the record that would indicate upon what basis the guardian ad litem made the decision to advocate placement with the father versus something else. And I'm not suggesting it was a bad call. I'm just asking you from the state of the record, is there anything in the record that would give us any insight into upon what the guardian ad litem based that conclusion?
Your Honor, I'm not aware of anything beyond the conversations that occurred at mediation, and that's not fully in the record. And then, of course, the documents that the father provided, that he doesn't have a criminal background, the evidence that he does have a relationship with this child, the evidence that the grandmother and the mother never provided any evidence that this guy was inappropriate. You know, I quoted in the footnote in my brief, when asked what would happen if NR was left with the father in Ohio, the grandmother's answer was that half-brother Z would be devastated. I mean, she didn't identify anything bad that was going to happen to NR. It was all about his half-brother who was going to be devastated. So nobody, and here's a maternal grandmother and the mom who know this man, nobody said anything bad about this father. This case, absolutely not. It's not an ideal example of how a dependency case should proceed. But what is true is that the guardian ad litem, after 2 years, took the bull by the horns and tried to get some stability in the life of at least one of these children, and did manage to accomplish it. The trial court's order does not say that the court was terminating jurisdiction over NR. But that's the net effect, because the court dismissed the dependency petition, gave sole custody to the father, said the father can live with this child in any state it wants, and there have been no further reviews pertaining to NR. So, by inference and by fact, the court has terminated its jurisdiction as to NR, and that's what was the father's right under 39-521, to have the child, to have the state prove its burden if it wanted to deny the father placement, and then the court in subdivision B1 has the right to terminate jurisdiction, and that's what occurred. So what happened here is that 2 years after the fact, the court proceeded as it should have done at the initial dependency disposition. So in a roundabout way, the court finally got to the point it should have been at back in 2006, 2007. So the guardian ad litem and would ask that the court affirm the trial court's decision.
All right, sir. Thank you.
I'd like to point out that characterizing 39-521 as an absolute vested right, I would argue, is not a correct characterization. 39-521 creates a legal presumption, which is rebuttable, and certainly the department brings the initial case and has the burden of proof in the initial case, but all of the parties have a right to request hearings on those issues. A parent has a right to request an evidentiary hearing under 39-521.
Well, I guess he didn't know about it, right?
Pardon?
I guess he didn't know about it, right?
Right, and there's absolutely no question that the department in the first case dropped the ball completely. And again, that brings me to my argument that in the second case, everybody knew about everything. But I do find it a little unusual.
If the department had not dropped the ball, he would have had custody of the child 2 years earlier.
Not necessarily. Had the department not dropped the ball, there would have been a 39-521 hearing, and the mother would have had to write to request an evidentiary hearing at that time, in which she would have had a right to rebut the presumption, and he might or might not have had custody. So to argue that had the department done it right the first time, the father would absolutely have gotten his child then is not accurate.
It's very troublesome, though, that a non-offending parent can have no notice of this proceeding, and this child could sit in limbo for 2 years like that.
That is absolutely true. Except that
the department hasn't come forward with any evidence that he's unfit or that his home is not appropriate. They're essentially saying the department's position is that. Or the mother's position, rather, is that he's got to come in and prove that he's a valid...
No, the mother wanted an opportunity to show that he wasn't. And please recall that in the TPR petition, the guardian ad litem himself made allegations of abandonment. And there's also, it's very easy now for the argument to be, well, the department dropped the ball and didn't file a petition in the first place. But the department did put a bunch of tasks in the case plan, so had the department done it right the first time, they may well have amended the petition that they should have filed in the first place. So this whole point of talking about what didn't happen the first time is pretty much pointless. They did in fact serve the father the second time. He was in front of the court. He did have notice of all the allegations. The allegations did include allegations of abandonment against the father. That's why 39-811 is relevant. That's why the whole argument about the first time was unconstitutional doesn't really matter, because we have everything in front of the court the second time with proper notice, with proper everything, and the first time is all speculation and out of the picture.
So when we remand the case back to the trial court, what happens to the child until the evidentiary hearing?
I would assume that what should happen to the child until the evidentiary hearing is whatever is best for the child.
The mother's position is going to be that the mother wants the child to go back to the mother's mother until we get through another year of
my thought would
proceedings, right?
My thought would be it's summertime right now, so it wouldn't disturb the child's schooling. Obviously, the first issue is always if the child is in school, nobody wants to yank the child out of school in the middle of school. So it is summertime. Perhaps the child could come down and visit grandma for the summer. And I would point out in relation to what the respondents' arguments were regarding the grandmother. The guardian ad litem gave a lot of testimony about the bikes that he gave the children, but he also admitted that he never visited the child in the presence of the grandmother. So he made all of these statements about the grandmother and her lack of interaction and how unfit she was. He never visited these children while they were with the grandmother. So I think the record reflects that the guardian ad litem's approach to this case may have involved some standards that indicate that maybe he was missing some things. Maybe there were some gaps in his analysis of the dynamics in this case that would give rise to some concerns about his recommendation regarding the father. But I would say in terms of your very excellent question about dealing with the child, perhaps a summer visit with grandma would result in a benefit to everybody and would not disrupt the child. Because I would never suggest that a child be removed from anywhere during the school year unless that child was in demonstrable imminent danger of harm. Let's see if I got all of my points. Okay. I believe... the other thing was that it strikes me as somewhat inconsistent to argue that it is unfair to the father and a deprivation of his fundamental due process rights to have done this initial case without ever giving him notice, but then to argue that it wouldn't have been necessary in that first case to provide for an evidentiary hearing under 521. Those two arguments seem inconsistent. So I think it's important and illustrates the point I was trying to make about even if you had done things right in this first case, it wouldn't have necessarily led automatically to the conclusion that respondent is arguing it would have led to. So I thank the court for its time, and I would request that you send it back for an evidentiary hearing. Thank you.
Thank you both for your arguments.